So we're going to open it up to Q&A. I want to just preface it by reminding everybody we have 200 plus people in the room. So we ask that if you're going to do a question, you pick your most important question to ask, and then we let everybody else have their turn to go through. We have a limited amount of time allocated, but we have the expertise here. So, and we've covered a lot of ground, so if you have a question, we'll get started. Carissa, we'll start with you.
On the proxy, you said like they could vote for question 2 and 4, but not for the others. And so as managers, when you're counting votes or board members, is it based on their honesty? They need to remember they can only vote for 2 and 4?
Well, the short answer is yes. We hope that the person with the proxy would respect their limitations. But the onus, of course, rests with the property manager and the others who are in control of the meeting to ensure that the people who vote, who can vote, have the legitimate, have the legal basis to vote. So ultimately, the responsibility rests with the people in control of the meeting, that be the board and or property manager, or both.
And I think, I'll jump in on that as well. I think the chairperson, whoever's chairing the meeting, so at the start of the meeting, we know we have waiving of the calling of the roll and certifying the proxies. Certifying the proxies means something, and the chairperson is there to do that, to certify them. So I think there's a responsibility that whoever is chairing the meeting needs to pay attention to those proxies and have them on their mind.
Thank you. I have one more question, if I may. You talked about things that are considered contributions, but I noticed that insurance deductibles weren't on that list.
So, good question, and we'll talk about that more in the chargeback, but I'll answer the question now. So, we've seen some change with insurance deductibles, and we've seen all sorts of, in the media right now about it as well. The ability of a condominium corporation to collect an insurance deductible has been permitted through the case law for about 10 years or more. So this isn't something new in the legislation that suddenly corporations can collect the deductible. That right was already there. But what it has done is it's crystallized it and it's clarified it. And that's what we've been asking for, quite frankly, for many years, is to give us certainty on that. So a corporation can collect an insurance deductible by pursuing the person in small claims court in what's called for debt, or alternatively, if permitted in your bylaws, through your board resolution, to then treat it as a contribution. So we still need those bylaws, and a lot of the bylaws that talked about act or omission or negligence, I think will need to be tweaked to give the corporation the full ability. But back to this issue of insurance deductible, the key information piece about this, it's the other side of the coin, and it has to be shared, and if you haven't shared it with your owners already, I encourage you to do so. Owners can get coverage to place or to cover if they have to pay that insurance deductible on their home insurance policy. So when I put it on my mom's condo and made sure she had coverage, it cost me an additional $60 for the year, $65 maybe, to get that $50,000 coverage. So I would encourage everybody in this room who's on the board to consistently pass this message on to your owners, circulate it, send out letters. This is legitimately worthwhile to do. Make sure you have coverage on your home policy in case you are assessed the condominium's insurance deductible.
On that note, we do have a copy of a tip sheet that we put together on this particular issue. It's available at the CCI table at the back. Go ahead.
She was there first.
We'll just alternate
Okay.
mics. I get to make the rules tonight. That's great.
All right, fine, thank you. I was pleased to see that you seem to emphasize that you had to keep the results of votes. We had an occasion where we had our bylaws changed, and I could never get any actual figures as to whether, all I got was the opinion from a board member that, well, it was passed. Am I right in assuming now that they will have to supply to me as an owner what the count was, the number of units that were for it and the number of units that were against it? And
If you ask, yes. That's information you're titled to under 20.52.
yes, specific, not general.
Yes, the results of the vote for special resolutions.
All right, thank you.
Go ahead.
No.
Okay, I'm gonna try to speak really loud. Oh, maybe I'm not. Okay, how about okay? My condo board, we had our. Okay. Hello. Okay. We had to do a special levy, but I just realized in what's listed here, the board resolution. We didn't include the date of the special levy
The-
paid by.
The mic's out, go ahead.
Okay. The date the special levies paid by. So does that mean that in our next board meeting, we have to do a new resolution with all the information?
Yeah, so the word must there that's a recommendation. It shouldn't be must. It should say the board resolution ought to include or should include. If you want to like, I like the clarity and the formality of this. So one of the reasons I like the formality is when we go to collect it, if somebody doesn't pay, there's really sophisticated litigants on the other side, being the banks, who have the experience and the resources to challenge it. And they will challenge on technical grounds to try and protect the mortgage if they can. Happens more in cases these days where maybe the mortgage is worth more than the market value of the unit, right? So I like the technicality. So if you have to make an amendment or a clarification statement or a supplemental motion, it's okay to do it.
Thanks. Thanks for taking, thanks for taking my question.
Just speak right into the mic.
Okay, we're in the process of needing to do a special assessment, so I have two questions. Is it proper to have a meeting with the homeowners, or can we just, as our bylaws state, figure out how much we need for the assessment?
In my opinion, when we're talking special assessments, especially larger ones, I like having the meetings or a series of meetings. The more you engage the owners, then the more they understand that board members are owners as well, and they're not just spending money flippantly. The questions typically end up in 4 categories. What do we have to do? Why do we have to do it now? How do we pay for it? Is there anyone we can sue? Right? But normally question 4 is, well, our building's 20 years old. No, we can't. It's just time to fix something. But if you prepare those categories, your questions, and share that with the owners, I think that's a good start.
Okay, we also have, there's a question on whether it's a capital project. We're a new condo complex, 4 years. We've, don't have a large reserve fund. We've been putting in what we need to. We've got some underground piping that has come apart, and and a couple of other things that are going to require like $50,000, and our reserve fund is at like 65. Some homeowners would, of course, like us to take it out, but I feel like we would put our complex and have it being pretty vulnerable if we take out that money. Like, we have to put it back somehow. So any suggestions? Can we just assess and just explain to them that we don't want to use our reserve fund for?
Yes.
Good.
And I think it's important to keep in mind that the reserve fund is not a slush fund.
Right.
So it's there and it's tied to certain requirements. So again, if the work is not tied to the reserve fund, those funds are not available for the work that needs to be done. It's not a pool of money available to you for whatever reason.
Right.
For a capital project. So it's not as simple as saying, well, we've got $65,000 in a reserve fund, and we'll use that money to fix this problem without following your reserve fund study plan that you've adopted as a board.
Okay, that answers, because yes, that's the same page I was on. Thank
Okay,
you.
thank you.
Building upon this issue, you'll sometimes see owners that they don't like the special assessment, so they want to try to pass a resolution that we're not going to have the special assessment. I always give the legal opinion they can't do that. That if owners don't like the special assessment or the special levy, that they have to remove the board, which they have the ability to do under, I think it's 30.1 or section 30. However, those new board members coming in are going to have those statutory obligations that fall upon them if they choose to just ignore the maintenance obligations that they have and expose themselves to some personal liability.
And I'll jump on that. If you have, board members, you have to be reasonable and prudent. If you have the opinion of an expert that says you need to do this work, is it reasonable and prudent to ignore that expert opinion? No. I think when you do that, you're drawing a bullseye on your chest and probably risking your protection under your director and officer liability insurance. Your remedy, if you don't like the expert's opinion, is to get a second opinion. So sometimes when we have these owners are angry, they throw the board out, well, you're still stuck with that same opinion. You need to do the roofs.
And an opinion is not my brother-in-law or my buddy.
Or I
Just to
know
be
a guy.
clear.
Yeah.
A few minutes ago, there was some conversation about proxies and the question about the results of the vote. Would you please clarify what the results of an ordinary resolution are? Are they the number of for and against, or are they carried or defeated?
For and against. I
So
would
is
be, well, I would be prudent and put it, I wouldn't be, there's nothing specifically indicating that in the regulations, but I would be prudent and put that level of detail in there. I mean, there's no downside having the information in the minutes. And again, it goes back to an earlier question, that in the event that there is an issue of the legitimacy of the vote or someone challenging the vote, you've got at least some documentation to set out the vote count.
Thank
So
you.
it's more work, but I like more.
I think I might take a bit of a different perspective on it in that if it's a written ordinary resolution, I think for sure keep the results and disclose them like that. But if it's something like approve the agenda, I think you're okay to say motion carried at that point. But if there's any ordinary resolution that's contentious or in writing, I think I would agree with Robert, err on the side of caution and make sure you put.
Under change of board of directors, if the board of directors and the address of service is not changed, has not changed at a meeting, do you still have to submit that Form 8?
After every AGM. Yeah.
After every AGM,
Yeah.
even if there is no change?
Yes.
Oh, okay. And one other quick question. I presume that when we're sending out the notification of meeting for the annual general meeting, and it says annual financial statements, those are the audited annual financial statements?
Unless there's
review.
no audited statements. There might be, the financial statements might have been done by review. So you don't have to have audited statements.
Oh, okay, so like we get audited, we do have an auditor that audits our statements, but in this case, it would mean she normally has them ready for us the day of the meeting, but we have our own financial statements that we do up ourselves, so.
So now, you
Now.
have to put that audited statement, like the statement from your auditor. If you're getting an audit,
Yeah.
that has to go with your meeting package. You
Okay.
shouldn't be panicking with it.
That was
Okay,
always the
perfect,
case.
thank you.
If I could just build upon one issue with the whole notice of special meetings. Quick quiz for those who are paying attention. You got a general meeting. How much notice do you have to provide? No. 14 days. Maybe. Right? Think about this for a second. 14 days is 14 days the amount of notice you have to provide. And if you're mailing things out, what's the amount of minimum notice? 7 days. So it's 21 days. So too many people look at it and they go, oh, special general meeting, 14 days. They forget the mailing part. So just today I was looking at a notice on a very contentious matter where there's already 3 lawyers involved. The letter was dated January 2nd for a meeting to be held on January 21st. It's contentious. There's lawyers involved. There's been court proceedings. And before they're out of the gate, they've got a 19-day window. They're already offside. So it's a simple issue, but it's one you have to pay attention to when you're looking at service of documents. What is my actual date that I need to have?
All right, this is our last question for this portion. Go ahead, sir.
In the discussion on rules, it was mentioned that rules should not apply to units or what happens in units. At our condo corporation, we have a rule that regulates ornaments, lawn ornaments that are attached to a unit. Would that qualify then as a proper rule?
What in the world do you have against garden gnomes? You know, every once in a while, you just see these unreasonable positions at these meetings. They're cute. What's the problem?
Well, the problem can be they can be all different sizes, colors, descriptions. They can be placed
Well, I think
in many different places.
it comes down to two, you answer your question in two parts. Are you a conventional condo or bare land?
Bare land.
Okay, so with your bare land, if your managed property definition includes the outside the home, then you can put a rule for that because it does allow it for managed property. If you're conventional condo, because it's outside the unit, you can have a legitimate rule for that. It was actually CCI who, back in 2014, pushed and actually surprisingly got an amendment through on the proposed legislation. Because the idea of having rules affecting what you do in your home, you could have boards unilaterally at board meetings saying, well, I don't like that, guys, so we're going to make a rule that you can't have pets. Or I'm going to make a rule that you can't cook this type of food or whatever, right? So the idea is let people live in their home, but garden gnomes outside, if your managed property and your bylaws describe what managed property is and considers your grass, then I think you're okay to talk about garden gnomes in your rules.
One other thing, what about noise, let's say, that's generated within a unit and affects,
I think that should be in your bylaw.
and not as a rule?
No.
If you want to be specific, you want to have it in your bylaw. Most bylaws already have kind of a nuisance general provision in them. And even if they don't, arguably, you now, with the rewording of Section 67, you have some abilities there when a unit owner is acting in a prejudicial manner. If I could circle back on one point, there was a comment that Roberto had made on rules. When he's talking about proxies, we were talking about best practices and how you can, by rule, set out what the proxy looks like. So if you have a proxy that checks off all the boxes of the regulations, but isn't in the required form of the rule, do you accept that proxy?